Ladies and gentlemen, welcome to the National Constitution Center and to the first program in the new season of America's Town Hall. It is wonderful to reconvene after the summer and to see all of you again through the magic of Zoom, and let us inspire ourselves for the learning ahead today and all year by reciting together the National Constitution Center's mission statement. Here we go. I know you remember it by heart. The National Constitution Center is the only institution in America chartered by Congress to increase awareness and understanding of the U.S. Constitution among the American people on a non-partisan basis. We have a superb season of light and learning ahead, and you can check it out on the website at constitutioncenter.org. Just to plug a few of the upcoming programs, on October 7th, we're going to host a program on the question of whether qualified immunity for police officers should be abolished. On October 13, we talk about patriotism and dissent throughout American history. Later in October, we'll have a great debate about how we understand American constitutional history between Wilfred Coddington and Charles Kessler. And on November 19th, we will discuss the influence of indigenous people and tribal governments on the U.S. Constitution and American democracy to celebrate Native American Heritage Month. Check out all of those programs and more at constitutioncenter.org/debate. And we'll be taking your questions throughout the show, so please put them in the Q&A box, and I will submit them to the panelist as best I can. And now I'm so excited to introduce you to three of America's greatest scholars of religious freedom and the Free Exercise Clause to debate one of the central questions in American constitutional law today. To what degree does the First Amendment to the Constitution create a presumptive right to exemptions from generally applicable laws for religiously motivated groups and individuals? To introduce the show, I'm delighted that we're presenting it in partnership with the University of Notre Dame's Center for Citizenship and Constitutional Government. And I want to thank Phillip Muñoz, who's the founding director of the Center for Citizenship and Constitutional Government, and who's one of our panelists today, for helping us put together such a great panel. So let me introduce Phillip and his other panelists, and then we will dive right in. Vincent Phillip Muñoz is Tocqueville Associate Professor of Political Science and concurrent Associate Professor of Law at the University of Notre Dame, where he serves as the Faculty Director of Undergraduate Minors in Constitutional Studies. Congratulations to Phillip for recently winning a National Endowment for the Humanities Fellowship to support his forthcoming book on the natural right of religious liberty and the original meaning of the First Amendment religious clauses. That's scheduled to be published by the University of Chicago Press in 2022, and it's the subject of our panel today. And Phillip's first book is God and the Founders, Madison, Washington, and Jefferson, and he's written other great books as well. Kathleen Brady is Senior Fellow and McDonald Distinguished Fellow with the Center for the Study of Law and Religion at Emory University. Her book, The Distinctiveness of Religion in American Law, Rethinking Religious Clause Jurisprudence, was the recipient of a book award from the Catholic Press Association in 2016, and she has also taught at Villanova and the University of Richmond School of Law. And Douglas Laycock is Robert E. Scott, Distinguished Professor of Law, Class of 1963, Research Professor in honor of Graham C. Lilly and Peter W. Lowe, and Professor of Religious Studies at the University of Virginia School of Law. He's widely regarded as one of America's leading authorities on religious liberty, and his many writings have been republished in a 5-volume collection, The Collected Works on Religious Liberty. He's also the author of the leading casebook, Modern American Remedies, and the award-winning monograph, The Death of the Irreparable Injury Rule, and many articles in leading law reviews. Welcome, Phillip, Kathleen, and Doug. Phillip, I'm going to begin with a quotation from James Madison, which you cite in your writings about natural law and the framers. Madison said that the opinions of men, reflecting the evidence presented to their own minds, cannot be compelled by other men. And for that reason, he said that freedom of conscience was an unalienable right. I can't alienate to you the power to control my thoughts because I can't entirely control them myself. They're the product of my reason and reflection. tell us more about Madison's original understanding of the rights of conscience as a natural right, and why you believe that Madison and the other framers did not think that the Free Exercise Clause of the First Amendment created a presumptive right of religious exemptions from generally applicable laws.
Well, thank you, Jeff. Thank you to the National Constitution Center. Let me speak just for a second in my capacity as director of Notre Dame Center for Citizenship and Constitutional Government. I mean, we're just thrilled to co-sponsor this event and thrilled to be here with Kathleen and Doug. I mean, Kathleen's book is really just a phenomenally good book. For those interested in this subject, I would encourage you to start with her book. And then Doug, of course, is one of the nation's leading scholars on this subject. When you asked if I would participate, I was eager to do so just so I could actually listen to them. So I'm going to try to speak shortly and let them speak at length. You asked about Madison and the framers and the idea of natural rights. And so this is something I've been trying to understand. The founders called religious liberty an inalienable natural right. We see this in their documents, the Memorial Remonstrance, which Madison wrote in 1785, Jefferson's Virginia Statute for Religious Freedom, with Virginia adopted in 1786. But you see it all, the same language throughout the founding era, especially in the state declarations of rights. Not every state had a Declaration of Rights, but most of the founding era states did, and starting with Virginia's and then finishing with New Hampshire's in 1784. So the language was the same. You could say this is the common understanding. Religious liberty is a natural right and an inalienable natural right. So the question is, what does that mean? It's not altogether self-evident what it means to have an inalienable natural right. In my understanding, and very, very prominent scholars disagree with me here, but in my understanding, the founders thought was something like this. Because of the nature of how our religious opinions are formed, as you mentioned, through persuasion and evidence alone, and also because we have superior obligations to God through the nature of religious obligation. When we create a social compact, when we institute a government, we don't give to that government jurisdiction over our religious exercises. So the rights of religious liberty, the natural rights of religious liberty, are inalienable in a literal sense. We do not alienate authority over those rights to the government. Now, how does that translate into constitutional law and constitutional doctrine? I think it means that in the founders' understanding, that the government lacks jurisdiction over religious exercises as such. A couple examples, that's a little bit abstract. We don't give authority to government to issue preaching licenses. I mean, you have to have a license to do many things, many professions, a teaching license, a law license, a marriage license, cosmetology license, but we don't have preaching licenses. And why can't the government issue preaching licenses? You are certified to preach the Gospels or preach the scriptures or whatever they are. Because government doesn't have authority to issue such licenses. Government doesn't have authority to issue such licenses because we, the people, never gave it authority over our religious exercises. So you can't make laws for religious exercises. You can't punish religious exercises. You can't punish the absence of religious exercises. So it's a jurisdictional concept, I think. What that means when they wrote the First Amendment would be that Congress, and with incorporation the states, can't make laws that target religious exercises for prohibition or even promotion. But it's a very limited and narrow right. It doesn't mean that when government is exercising its legitimate authority and raising a military or passing taxes or making general laws for the conduct of society, if those laws impact religious individuals, as long as it's within the original or the proper jurisdiction of government, then religious freedom doesn't give you a right to be exempt from those laws. So the way I like to talk about it is the founder's idea of religious liberty is a narrow but deep concept. It really protects the core exercise of religious worship.
Thank you so much for that. Kathleen Phillip's work is significant. As he said, not all agree. And he is arguing that as a matter of original understanding, the First Amendment does not create a presumptive right to exemptions from general laws as long as the law has a valid civic purpose. Do you agree or disagree, and why?
Thank you very much, and thank you for the opportunity to be here. I agree with Philip that the First Amendment should be construed to prohibit the government from directly interfering with religious beliefs, worship choices, and to that extent, there is a distinction of jurisdictions between government and religion. But when I construe the Constitution, I look both at what the founders and those who ratified it may have understood it to mean at that time, and more broadly, what were the principles that they had in mind. And I think the fundamental principle, and this is connected to a number of things that Philip said, the fundamental principle is that government should not interfere with the choices of individuals with respect to their religious professions and practice. And for those in the founding era, that meant primarily not intentionally interfering with those matters by directly compelling or suppressing religious belief and practice. That was, after all, their experience. That was the experience in the colonial era. That was the experience in Europe. And that is primarily what they had in mind. But the reasons that they were concerned about that go deeper than just that expectation. And part of the reasons are related to what Philip said with respect to the primary importance of religious convictions for religious believers. Believers have a primary obligation or allegiance to the divine. That's how religion works in the lives of believers. And in his memorial remonstrance, James Madison mentioned that the duty to the Creator takes precedence in terms of time and degree of obligation to the claims of civil society. And Thomas Jefferson, when he was on the board for the new University of Virginia, was part of the authors of a report that called the relations between individuals and their makers the most interesting and important thing in their lives. And for those in the founding era, that connection, that possibility of connection between people and their creator or the divine, more broadly understood as we would understand it today, not just in theistic terms, gave people a special dignity by virtue of that ability to ponder and to relate to the origin or source of all being. And Madison actually called conscience a sacred castle. So it was a sacred matter, and that meant that there was a jurisdictional divide of sorts. Government did not have a role in religious matters, but I think that it went deeper than that. Whether they had an expectation with respect to what the Constitution meant at the time is a matter of debate, but they certainly expected governments to be solicitous when conflicts arose. And as a matter of fact, governments in the founding era were quite solicitous when pacifists didn't want to fight in the Revolutionary War or in general. Accommodations were made. When religious groups didn't want to take oaths, affirmations were allowed at the state level. And in the first Congress, you see a debate over whether or not the First Amendment or the Bill of Rights should include a protection for religious pacifists. Everyone agreed that religious pacifists should be protected. The question was whether or not the protection needed to be part of the Constitution, whether it should be a matter of legislative responsibility or benevolence. Instead, whether the protection should be understood as part of that core idea of the rights of conscience, or whether or not, again, it was a matter of legislative right. But everyone agreed on protecting conscience because there was a shared idea that individuals, that relationship with the divine was primary, that people should follow where conscience led. Not that there were no limits, there were certainly limits in state constitutions. It was not an unlimited right. But when you ask today, how should we understand the Constitution? I don't think we should just count heads in terms of what would people have expected in the founding era the Constitution to have meant then. Philip may be right. that they just primarily had in mind intentional interference, but they certainly were solicitous of conscience in general. And today, when we can no longer count on the kind of benevolence that they counted on, that those who debated that protection for conscientious objection for the Bill of Rights, by the way, is not in the Bill of Rights. They expected legislative benevolence. They expected it because the moral divides were not as deep then. Conscientious objection was a matter of moral perfection. It was not a matter of real, genuine moral pluralism. We can't expect that kind of benevolence today. We have huge fights about these issues. So today, respecting conscience requires, I believe, us to interpret the First Amendment in light of the principles and the reasons that underlie that principle of respecting conscience, that relationship between individuals and the government. And as a matter of fact, as shortly after the adoption of the Bill of Rights, you see a liberalization in the states about what the idea of free exercise meant. The time that the nation began, you had a lot of restrictions on who could hold office, religious tests for office holding. Those quickly were removed. And in Torcaso versus Watkins in the 1960s, the Supreme Court held that kind of imposition of civil disability on office holding was a violation of free exercise, even though those who drafted the First Amendment probably wouldn't have understood it that way, because that kind of restriction was commonplace, but it was inconsistent with their principle of non-interference with matters of faith and the underlying reasons for that, which was a respect for conscience and also a concern about civic divisiveness. If you don't respect conscience, it's just such an important matter to individuals.
Thank you so much for that nuanced and thoughtful response. Doug Laycock is still working on getting his camera on. So Philip, I'm going to go back to you until we can see Doug.
Get him back.
You're back. We can't see you, but we can hear you like an oracle, Doug. So if I were to, I'll ask you a question, and if you can, that would be great. Doug, you've written in your scholarship the question of whether the First Amendment required religious exemptions was debated at the time.
I see a start video and it's not.
Sorry, Doug, if you can just mute until you're on. I'll for our friends who are noting, Doug in his path-breaking briefs has said that the question was debated at the time of the framing, and he notes that the central question of Quaker pacifism was often given as an example. Philip, I think I'll turn this back to you because we still don't see Doug. You say you see the question of the fact that Quakers were sometimes exempted from military service as a point in your favor, because you note that these exemptions were not granted as a result of state or federal constitutional religious free exercise provisions, but just under the authority of state constitutional provisions that specifically recognized a right of conscientious exemption from military service or through ordinary legislation. And just to put this point sharply on the table so our friends who are watching understand this, your argument about Quaker exemptions, Philip, suggests that the conservative justices on the Supreme Court are wrong when they cite these Quaker religious exemptions as a point in favor of a broad constitutional right in favor of religious exemptions, because you say that they were granted at the time of the framing as a matter of state constitutional law or as a matter of legislative grace, not in terms of the understanding of the federal constitution. Tell us more about that argument and why you think the Quaker exemptions do not cut in favor of broad religious exemptions under the First Amendment.
Sure, great. Those are very thoughtful questions. Let me back up maybe just a little bit and just try to clarify. There's actually two debates or two questions we're wrestling with. The first is more historical. What is the original understanding of the free exercise clause? And that's a matter of history and the philosophy that animated the drafting of the Constitution and the Bill of Rights. But that's primarily a historical question. And then there's a related, but really a separate question: what's required or what's necessary or what's the best constitutional way to protect religious freedom today? Now, you could have the same answer, or you might have different answers. Those scholars and justices who are originalists are particularly interested in the original understanding. Of course, my work is to try to articulate the original understanding, but that's prefatory, I think, and you have to figure out what the original understanding is. I mean, I guess if you're an originalist and a judge, that's binding on you. My work as a scholar is to say, well, this is the original understanding. Once we have that knowledge, then we have to think about, well, should we follow the original understanding? Is it relevant today? Is it not relevant? Does it still work? And those are really separate questions, I think. So let me focus on the original understanding, but recognizing that things Kathleen said, this is really Justice Brennan, the great liberal justice of the second half of the 20th century. He's really the modern author of the exemptionist approach to the First Amendment. And he was very clear, whatever the original understanding is, really Kathleen was articulating his position quite nicely. To protect religious freedom today requires a more robust understanding than the founders, he thought, more judicial protection. So there are really two questions here. What is the original understanding? And then what makes most sense today? What would be the best constitution today? So let me just focus on the first one for a second, addressing the question you asked about Quakers. So Quakers, of course, are pacifists, and they don't want to fight. They believe, let me rephrase that. They believe their religious commitments do not allow them to engage in warfare. Obviously, America was born out of a revolutionary war. And so George Washington, our first president, faced this directly as commander in chief. I mean, Quakers were, a group of 7 Quakers were marched with guns tied to their backs because they wouldn't carry them to Washington. And Washington did what I think any good general would do. He said, look, to the Quakers, go home. He wasn't going to make them fight and violate their conscience. Now that said, so what Kathleen says is exactly right. Quakers were accommodated both in practice by George Washington, by the first Congress, by state legislatures, but these were always done legislatively. The question for the First Amendment is, do individuals like the Quakers have a right to be exempt, a constitutionally guaranteed right to be exempt? And here, I actually think the record from the original record is pretty clear. As Kathleen mentioned, they debated this question in the first Congress. The first Congress drafted the First Amendment. So in the middle of the drafting of the First Amendment, some people said, let me rephrase that. In the middle of the drafting of the Bill of Rights, some people said, we need a provision to exempt Quakers. That debate actually occurred when they were drafting the Second Amendment relating to militia, not the First Amendment, which is interesting and revealing, I think. They adopted the text of the First Amendment, and then they had a debate over drafting an amendment about Quakers. I think that implies an exemption wasn't in the First Amendment. Scholars disagree on that, but nonetheless, they had this debate in the first Congress. Should we have an amendment to protect Quakers and other pacifists for religious conscious reasons? At one point, the House of Representatives adopted a provision that would have extended a constitutional right to exemptions. But when they actually adopted the text, they rejected that proposal. So I actually think this is sort of definitive evidence. They proposed an exemption amendment and they rejected it. And if that's not clear evidence for what the original meaning of the Bill of Rights is, I don't really know what is. Now, again, that's just what the original meaning was, and maybe we shouldn't follow that today. That's another question. But it does seem to me that's definitive evidence. And that would mean, I mean, if I'm right, it means Justice Alito and Justice Gorsuch and Justice Thomas are wrong, at least in a historical perspective. Again, recognizing that there's more than one issue in this question.
Thank you very much for that. Kathleen, could I ask for your thoughts on that specific point? Do you agree or disagree with Vincent that Justices Alito and Gorsuch and Thomas are wrong on the specific question of religiously compelled exemptions? And if, for example, there were no exemption from military service for Quakers today, do you agree with him that the First Amendment would not compel it?
I agree with Philip about the original meaning of the First Amendment, although, and I have written to that effect, we agree that those who drafted the First Amendment and those who ratified it would not have expected the Free Exercise Clause to include a right of exemption protecting religious pacifists. Although I'll make a little counter argument here, Justice Alito in Fulton, he does point out that maybe conscientious objection was a special case where there were questions of national exigency at stake, right? Having enough fighters for a war is certainly a matter of great importance. So perhaps this was debated, the particular protection for religious pacifists was debated because it wasn't certain whether or not a limit on religious exemptions or right of exemption already in the free exercise clause would have applied. So maybe they understood the principle of free exercise to include a right of exemption, but this is a hard case, so they're going to debate it, and that's all that means. I find the argument interesting, Justice Alito's argument interesting, but not convincing. I'm with Philip. But for me, I guess I have a slightly different understanding of what a historical interpretation of the First Amendment means. In my view, you shouldn't end with what the original meaning or expectation was with respect to something like the free exercise clause, which is sort of it's not so specific that there's no matter of interpretation. Free exercise is sort of general idea to begin with. Obviously, I'm not going to say we should change something like the age of 35 to be president. But in any event, going back to what does a historical understanding mean? I still think I have a historical understanding. My view is that an understanding of history has to look towards what the principles and concerns were of those who drafted and adopted the Constitution. Because if you don't have that deeper historical understanding, your interpretation over time might become disconnected from those concerns, from those principles that I believe are so important. And to give you an example from the organizational context, because after all, Fulton did involve a question of organizational religious freedom. In 2012, the Supreme Court recognized a ministerial exemption to neutral, generally applicable employment discrimination laws. So neutral, generally applicable employment discrimination laws cannot interfere with the choice of clergy by religious institutions. And the court pointed to particular history in England and America where the government was directly interfering with the choice of clergy. But in 2020, the court expanded that understanding of a ministerial exemption to be a broader understanding of key employees. And then it started talking in terms of a principle, what it called a broad principle of church autonomy. And underlying that broad principle, and it's the essence of that broad principle, was the idea that certain matters of church government that are critical to religious mission and interference of which would impact the development of religious faith and doctrine, those have to be protected from government interference too. So the court itself, the conservatives on the court moved from just, what were those in the founding era thinking of? What were their concerns at the time to an understanding of their principle? What was the principle behind saying the government can't directly interfere with the choice of ministers? Well, the principle is you don't want to interfere with the development of doctrine in a religious institution, and what might that require today? So that's the kind of historical analysis that I'm doing. It's not that I'm not doing historical analysis, it's just a slightly different kind of it. Though I'm interested in original meaning, it's just that I say, well, let's get what are the concerns that lay behind that, the broader principles.
Thank you so much for that. Well, Doug, we hope that you're able to participate by audio, not video, like the justices of the Supreme Court. So calling on you like the oracular voice, I want you to adjudicate this crucially important question. So Philip and Kathleen have agreed on something important, although they have different perspectives, that Justices Alito, Gorsuch, and Thomas are wrong to say that the First Amendment, as originally understood, would have required broad religious exemptions. On that particular point, do you think they are correct or not?
Well, I apologize. We had a lot of technical problems on my end. I could hear all of you. Can you hear me now?
Yes, you sound great.
Good.
Thank you so much for staying with us. And it's great to have you.
I don't think there's an answer to that question. I think in some ways it's a question based on a mistaken premise. The general right to exemptions was not a serious issue in their time, and it wasn't where their attention was focused. Their attention was focused on how to finance the church, what to do about church taxes, what to do about established churches, how to go through the process of disestablishment. They dealt with exemptions one issue at a time, and because they had much more religious homogeneity than we have, and much less government regulation than we have. So the issue arose only occasionally, but it did arise, and regularly legislatures granted exemptions. And it wasn't just military service. The Quakers were also exempted from swearing oaths. In a couple of colonies, they were exempted from removing their hat in court. That stemmed from a famous incident with William Penn. The Jews in Rhode Island were exempted from the Christian incest rules and allowed to apply their own rules. And every colony that still had a church tax exempted dissenters from it, from paying it eventually. So when confronted with issues of religious liberty, their conclusion was exemptions are necessary to implement it. And that was true even in the colonies with the most intolerant histories, like Massachusetts and Connecticut, where they once hanged Quakers for being in the state. Once they said Quakers can live here, they pretty quickly followed up with, and they don't have to serve in the military and they don't have to swear oaths, because the declaration they could live here didn't accomplish any of its purpose if they couldn't also practice their faith when they were there. Now, as Professor Muñoz says, these didn't come from courts. They didn't have judicial review yet in colonial courts. So that didn't tell us much of anything. But the societal reaction of that generation was, when faced with these exemption questions, you should exempt if workable and feasible. The issue of exemption from military service tells us almost nothing about the general issue, because that is absolutely the hardest exemption question. On the one hand, whether you agree with it or not, everyone understands the moral weight of a conviction that I cannot kill, right? We all believe thou shalt not kill, just some of us make more exceptions than other people. So it's a powerful claim to exemption, but it's also a powerful claim to government compelling interest, right? They granted the Quakers exemptions during the Revolution when national existence was on the line, when Philadelphia was an occupied city. But do you put that in the Constitution? Specifically, military exemptions? Well, actually, they didn't, but a refusal to guarantee exemption from the military draft doesn't tell you whether the Constitution requires an exemption from giving communion wine to minors. It doesn't tell you whether it requires an exemption from letting ministers serve their churches, cases where there's not nearly the same kind of government interest on the other side. So they didn't have a formed intent one way or the other, is my view, but certainly the Second Amendment debate about military exemptions, I don't think begins to answer the broader question.
Thank you very much for that. And it's great to have your perspective, and I'm glad you can join the discussion. So Philip, to sum up where we are so far, two of you think that the framers didn't clearly require judicially created exemptions. And a third, Doug, says that it's hard to answer the question because there were legislatively granted exemptions, but they didn't clearly address the question of whether courts should create these exemptions. Let's now talk about the modern controversies. All of the most controversial questions in our before the Supreme Court now involving religious exemptions have to do with their scope. So from the Masterpiece Cake case to the Fulton case involving foster care in Philadelphia, the court so far has avoided squarely addressing how broadly the Constitution requires religious exemptions, although several justices have suggested that they're broad. When it comes to the modern cases, Philip, for an originalist justice, how broadly do you sweep? For example, to take the cake case, do you believe that a fair construction of the free exercise clause, as originally understood, and would require an exemption for the baker? And tell us about other cases involving exemptions from laws forbidding discrimination against LGBTQ people. How broadly should an originalist say that those exemptions sweep?
Sorry. No, these are good questions, and I'm glad Professor Laycock was able to join us. He's, as I said, one of the nation's real authorities on this. So there's a couple interesting threads. Let me try to pick up on all of them. One, Professor Brady had said something which I very much agree with. There are different types of constitutional texts. There are rules, and she mentioned the president must be 35 years of age. That's a rule. But then there are other constitutional texts which are principles. The free exercise of religion, I think, is a principle. And then she said, well, there's what the founders might have expected the principle to mean, but really, let's go, if we really want to interpret these texts intelligently in the modern world, we should look to the underlying meaning of the principle, or the principle itself, which she understands to be non-interference with religious choice. And I think Professor Laycock has written about autonomy and deeply held beliefs, or autonomy and religious choice. And I think that makes a lot of sense. I actually think the principle is different, though, than what they're saying. So that there's a real difference here. I really think the founders were trying to articulate a jurisdictional principle. And I disagree with Professor Laycock. I think they thought about this quite a lot, because they thought about the social compact quite a lot, and they thought about the meaning of natural rights quite a lot. I think he depreciates how intentional they were about trying to articulate the idea of an inalienable right to religious liberty and what this means. And for them, it meant a jurisdictional concept. We don't give government authority over this slice of our natural liberty, over our religious exercises. I think that's very important. I think that was very thoughtful. I think it's very intelligent. Whether that's still a worthy principle to follow today is a different question, but I do think they were considered. You just look to Madison's Memorial and Remonstrance, you look to Federalist 10, you look at Washington's letter to the Quakers. I mean, Washington writes to the Quakers after he's elected president. Quakers write to Washington saying, we're so happy you're president, someone who respects religious liberty. And Washington writes back to the Quakers, you're terrific citizens, except in your refusal to take up arms in the common defense. I mean, he scorns them for not performing the obligations of citizens. I think we forget that. He does say his wish and desire is that the law be accommodate them, but he doesn't agree with them, and he lets them know that, because citizens should fight in defense of their country. Right. And the general principle of the rule of law is the law should apply to everyone the same. Right. And I think that was a considered understanding of the founders, central to their constitutional project. Right. The law is not perfect, so sometimes you have exemptions, but for the law to really be the rule of law, I think the founders really did think that the law should apply to everyone. And if the law can't apply to everyone, we ought to really think of whether we should have that law at all. And I think that's the way they would have thought about it primarily. In these modern cases, I mean, the Masterpiece Cake Shop, Justice Kennedy said, look, the cake maker didn't get a fair hearing. It was clearly religious animus. They were targeting this guy for his religious beliefs, and you can't do that. And I think the record, I mean, that case is a singular case, and the record seems to suggest that. And there was similar things in Fulton, though. My general position is, at least according to the original meaning, everyone ought to follow the law. I mean, if you don't like the law, you find it oppressive, you should try to repeal the law. And maybe you want to have a conversation of what tolerance should look like, and how do we let people live and let live in a pluralistic society. But those are different than the original legal question of what the First Amendment provides.
Thank you very much for that, and for so clearly putting that principle. If you don't like the law, you should repeal it, and if it can't apply to everyone, then it shouldn't apply at all. Kathleen, what are your thoughts about the modern cases? You have a nuanced test for evaluating exemption claims. Just to get concrete, in the cases that everyone will know about, the Cake case and Fulton involving Catholic social services, as well as perhaps some of the vaccine cases or others, give us specific examples of what your test is and how it would apply in the case the court is considering.
Yeah. One of the, I'm going to sort of maybe split a tiny hair between Philip and Doug with respect to what were those in the founding era thinking about. Doug mentioned that they didn't have a formed intent about the exemption question, although they did consider, certain issues that did arise, and as they arose, they were solicitous. And what I think they definitely didn't have a formed intent about was the types of conflicts that we're seeing today, where, as I mentioned earlier, it's not a matter of moral perfectionism like pacifism. It's a matter of deep moral disagreement over issues like related to family and sexuality. And in the current circumstances, we can see that where there are these sort of deep divisions, there's not near the solicitude that you had in the founding era. And I thought I just pulled up George Washington's full quote. Philip mentioned this, and I think you can hear the solicitude. And I agree with Philip that he was exasperated by the pacifists. But here's the solicitude. It is my wish and desire that the laws may always be as extensively accommodated to them as a due regard to the protection and essential interests of the nation may justify and permit. So, as extensively accommodated to them as basically is possible outside of, the survival of the state, essential interests of the nation. So that's pretty solicitous, even though he was frustrated with pacifists. But we don't have that as a broad matter today, and we have a lot of conflicts because government is broader, and there's a broader understanding of what government purposes are. It's not the minimalist state of Thomas Jefferson, where he envisioned government as a matter of protecting people from injury from others and the like. It's a much broader state. Conflicts are much more common. So as you point out, our biggest hot button issues today over matters of family and sexuality, though there are plenty of little button issues that we often don't think about, where it may not be that it's people are not necessarily solicitous. They may just not notice what truly minority phase are facing. There may be bureaucratic inflexibility that doesn't have to do with not caring, and all of these things, have to be put into the picture of how should we interpret the principle that the founders enacted today. So how would I look at it? As I mentioned, I would interpret the First Amendment to include a right of exemption to be consistent with the founding era principle. But specifically, I would look and I would see what are the limits that exist in the founding era, both as a historical matter, because I think they make sense. So there were two types of limits that you saw in state constitutions. There were limits where religious practice interfered with the rights of others, and there were limits where the peace, safety of the state was at stake, like George Washington mentioned, or basic conditions of public order. Really, this isn't the compelling state interest test I would use. That's very vague. These are sort of more specific things that I think would be limits. So when it comes to a question of the baker in Masterpiece Cake Shop, the question there is the rights of others. And I do think that the rights of others are not just life, liberty, and property, but economic, but civil rights government benefits that ensure economic opportunity. But the question is, if something is important, like the rights of conscience, like free exercise is, it's not just a question of whether that interest is at stake, whether there are third-party rights at stake, but whether or not you need to impinge upon religious conscience in order to protect those rights. That's the specific question. And when you get to the COVID restrictions question, there it's a matter of also the rights of others, in this case, their right to health and life. So again, I think that's certainly an interest that limits a right of exemption, but the question then becomes what kind of restrictions are truly necessary to protect those interests. There has to be a tight tailoring between what the government does and what these interests are. And I think a lot of the problem is that we don't really look for solutions, compromises that really can exist or can be created if people were more solicitous on both sides of the issue. But that's where I think when you put a right of exemption into operation, what courts should be looking for, is it necessary to impose upon religious liberty in order to protect the rights of others or important matters of state security, peace, and order.
Thank you so much for that very thoughtful response and for addressing issues ranging from the Cake case to COVID vaccinations. That's a great response to one of our questioners, Cindy Berman-Rowe, my college classmate. Hi, Cindy, who asks, on a practical level, can schools and businesses deny religious exemptions for the COVID vaccine? Doug, I would love you to share your nuanced approach for how to identify whether religious exemptions are required. In your amicus briefs in the Masterpiece Cake Shop case and the Fulton case, you argued that in those two cases, free exercise did require religious exemptions, but you say that religious exemptions are not required in the case of COVID vaccines. So give us a sense of what principle you're applying and you think the court should apply to distinguish among these various cases, and whether or not you think the court should overturn the Smith case, which says that generally applicable laws don't generally require religious exemptions.
I'll answer those questions. Let me say just a word about some of the 18th century quotations that Philip and Kathleen were talking about. Yeah, they didn't directly address the question, right? What can we infer from George Washington noting his reservation about the Quakers while encouraging exemption? Or, what did Madison say in the Memorial and Remonstrance? Actually said our duties to God are prior to our duties to civil society and can't be waived. But there was no square debate on a general right to exemptions, right? We're trying to tease out implications of rather isolated statements that weren't directly addressing the question. On the modern cases, sure, the rights of others are important, but you got to say what kind of rights or how important rights. There are people who think they have an absolute right to the shade of white paint they approve of on their neighbor's house. So, there are rights that really protect people, and there are rights that are really more sort of preferences. In the gay rights cases, which get all the publicity but are really quite atypical. So let me start with the typical cases. The cases that get no publicity are about beards and long hair and grooming rules, about Amish buggies, about Saturday Sabbath observers, both Christian and Jewish. They're about a whole range of things that aren't very controversial and don't get much publicity. And if there's no right to exemptions in the free exercise clause, then none of those things are protected either. We do have deep disagreement about sexual morality, and that drives much of this conflict. And both sides, both the religious conservatives and the gay rights movement, are deeply intolerant of the other. They want total wins for their side and total suppression for the other side. Many of the outspoken conservative, and I'm generalizing here, obviously there are tolerant exceptions on both sides, but many of the outspoken leaders of the conservative Christian movement don't want gay marriage, don't want laws protecting against LGBT discrimination. 24 or so states don't have such laws because of opposition from that quarter. And on the gay rights side, they don't want any exemptions at all, or maybe the minister doesn't have to do the wedding ceremony, but that's it, no exemptions beyond that. And that makes compromise impossible. You have to either suppress this huge religious movement, or you have to suppress this much smaller but very important group of people with different sexual orientation. Exemptions make compromise possible. They allow both sides to live by their own deepest values. If we imagine a wedding cake baker in an isolated rural community and he's the only one around, then I think he has to make the cake. The right for the gay community to access the market, the government probably has a compelling interest in protecting that. The exemption for the wedding cake baker who's not a local monopolist is also about his right to access the market without surrendering his deepest values. The other issue that arises much more commonly, the issue in the Masterpiece Cake Shop case, was not access to the market. They were immediately offered a free cake by another good baker. I'm insulted. I'm offended. You turn away my business because you disapprove of my morals, and that's deeply offensive. And I understand that. That's a harm, but it's no greater harm than the harm to the baker of saying, you have to get out of business or surrender your moral commitments because everyone else disapproves of what you believe. That's not, protecting people from offense has never been a compelling interest in the free speech cases. The court has said that over and over, and it's no more compelling in the free exercise cases. The vaccine cases, I think, are very different. There's plenty, and courts, there have been a couple of preliminary decisions lately in joining vaccine commitments. I think those are deeply wrong. There's clearly a compelling interest in protecting the public health, and every court to have addressed the issue before the last month has said that, has upheld vaccination requirements against challenge on religious grounds. I think that is clearly right. The other COVID cases about churches meeting, can you hold a worship service is about as close to the core of free exercise as you can get, but I think the answer had to be no for some of those time periods. Those cases are argued on grounds of discrimination, that some of the commercial operations that were allowed to be open and meet were no more dangerous than a church service. I think the church service was more dangerous because people sit together in close proximity for long periods of time. You have to be very careful and very cautious and make sure you're not limiting worship more than absolutely necessary. But it was absolutely necessary for a time. And I think there was a compelling interest in saying no live services with large groups of people. So you have to kind of go case by case. You have to be cautious. But religious exercise involves conduct, and conduct creates more occasions in which it is really important to regulate than speech does. So sometimes the party seeking religious exemption should lose.
Thank you very much for that, Doug. Well, it's time for closing thoughts in this deep and significant discussion. I just want to note two pieces that caught my eye online this morning. One is that in Ohio, the legislature has recently adopted a law that says that health providers and insurance companies have the freedom to decline to perform, participate in, or pay for any healthcare service which violates the practitioner's or payer's conscience as informed by the moral, ethical, or religious beliefs. And on the other side of the exemption scale, there was a piece in the Post arguing that if someone believed in good conscience, according to the dictates of their reason, that life did not begin at conception, but instead began around viability, they should have the ability to opt out of a Texas ban, which forbade abortions after 6 weeks. So recognizing that a strong presumption of religious exemptions can cut in both of these directions, I'd like each of you to give us your closing thoughts in just a few sentences and tell us if the court continues to adopt a strong presumption of exemptions from generally applicable laws under the First Amendment. Where do you think this is going? Philip, first thoughts to you.
Yeah, let me just say thank you again to Jeff and to the National Constitution Center, to Kathleen and Doug, and it's a privilege to be a part of this conversation. So two closing thoughts. I mean, one, we should. if Doug was the whole Supreme Court, I mean, his judgment, I think, is very good in the nuance on exemption in this case and non-exemption in that case, and all the factors on how close are people sitting, how many bakeries are in the town. Those are all very reasonable considerations, I think. I suppose my problem with that is it's not clear to me how you get that out of the First Amendment, that the First Amendment means one thing if there are several bakeries in town, it means something else if there's only one bakery. That's just not how I think a constitution is supposed to work. I think these are legislative judgments. I would certainly vote for Doug as my state legislator. His judgment's very sound, but I just don't think that's the rule of law, to be candid. On Kathleen's point about, look, our society is more regulated. The law does more now, and therefore there's more conflict with religious organizations, especially given the polarization and deep moral divisions in our society. I think that's all obviously true. She's exactly right. One way is we have lots of regulation of private conduct and lots of exemptions for us to get along. Another possibility is we have less regulation of private conduct and fewer exemptions. And we learn to go back to that old-fashioned value of tolerance, and we just let people live their lives and try not to interfere with them. That's sort of my favorite policy position. I wish we would all just be more tolerant and let people live their own lives, and not try to regulate or legislate them out of existence. I think that's still the common sense America, and I think if we did more of that, we'd need fewer exemptions. But those are legislative considerations, I actually think, not legal considerations. Not constitutional considerations.
Thank you so much for that. Kathleen, your final thoughts. Sorry, you're muted. Kathleen, you're muted. Sorry.
Apologize. Yes, thank you. My final thought's going to take off from your question, but turn it in a slightly different direction. And what you raised was the issue of if we have a presumptive right of exemption for claims of religious conscience under the First Amendment, what about claims of moral conscience that aren't religiously based? Where are we heading? Should we incorporate freedom from moral conscience more generally, not just religiously based conscience? And if we're heading in that direction, how broad is it going to be? And I actually think that it's important to respect non-religious moral conscience for a number of reasons, but religiously based claims of conscience are different, and that's one of I think the thing I want to leave with. They're different because they involve the relationship between individuals and the divine is, as Thomas Jefferson mentioned in that board report for the University of Virginia, the most interesting and important thing for human beings. And one of the reasons that the Smith case in the court, which held no exemptions, hasn't stuck all of these years is because it doesn't fit with human nature. It doesn't fit with the fact that many Americans are religious, probably always will be religious, because there is that capacity to question our existence, to think about the idea of a divine, at least, and to strive for a relationship with the divine. And being as important as that is for people, I believe that something like the Smith rule just won't stick. It doesn't fit with human nature. It doesn't fit with human history, and what will continue are very likely to be the makeup of American society. That there'll be a lot of religious people. And the other thing that happens when you have a rule like Smith that doesn't stick it doesn't stick because it doesn't fit really very well with human nature, is it's destabilizing. And I think that our fights about religious exemptions have become so destabilizing in our country, and see the dangers of not accommodating conscience. Of course, with limits in mind, always have to be limits. Otherwise, it'd be destabilizing on the other side. But these sort of fights have fed civic distrust. They've fed polarization. They've fed the politicization of religion on very, very, I think, dangerous ways. And I think understanding the distinctiveness of religion and the importance of the claims of religious conscience to people, and having a rule that fits what the founders understood about that importance, fits with the reasons behind their principle, would be more stabilizing and also better fit human dignity.
Thank you so much for that. Doug, last words to you. although you're muted as well. There we go.
Yeah, it's fatuous to tell deeply unpopular religious minorities in a highly polarized society to go to the legislature. Conservative Christians cannot win a legislative battle in blue states, and the LGBT community cannot win a legislative battle in red states. Yes, we ought to all be more tolerant, but we aren't. And the judiciary has recognized for 80 years now, part of what it has to do in the enforcement of constitutional rights is protect unpopular minorities that are largely shut out of the legislative process. And the First Amendment is written in absolute terms. Congress should make no law prohibiting the free exercise of religion, bridging freedom of speech. The court learned a long time ago you can't literally say no law. There have to be exceptions when there are really important reasons for overriding those absolute constitutional rights. And yeah, that leads to some fine line drawing sometimes, like, is there another baker available? Is there not another baker available? Where does that come out of the Constitution? It comes out of the necessity of making implied exceptions for cases of necessity, and they should be limited to true necessity. They shouldn't be limited to how popular we think a particular exercise of the constitutional right is. Keep in mind that when Smith first came down, Congress passed the Religious Freedom Restoration Act unanimously in the House and 97-3 in the Senate, and Bill Clinton enthusiastically signed it. The right to exemptions did not seem so polarizing before it was consumed by the deep polarization over sexual morality. And we cannot let that particular issue swallow the entire right to exemptions. Smith should be overruled because it vastly complicates every litigation. It's not as important as it once was because the conservatives on the court have taken the exceptions to Smith and extended them as far as possible. And so they can nearly always find a way out from under Smith. But both sides and the court waste an awful lot of time litigating those exceptions. It would be better to go straight to the real issues. Is there a serious burden on religious liberty here? And is there a sufficient necessity for imposing that burden? And one final note. The Supreme Court appears polarized on these issues, but it's not as polarized as first appears. There have been a number of unanimous decisions granting exemptions. The liberals care about religious liberty, but they care about gay rights and women's rights more. The conservatives care deeply about religious liberty. They care about capital punishment more. On Monday, I filed a brief in a capital punishment case, and in all the precedents, most of the conservatives were voting against me. So, both sides care about religious liberty, but they both have other issues that they care about more deeply.
Thank you so much, Phillip Muñoz, Kathleen Brady, and Douglas Laycock for a really significant discussion about one of the central issues before the courts today. Friends, thank you for joining, for taking an hour in the middle of your days to learn and grow together. And your homework is to read. Go to the chat and read the great books and articles of our panelists and read the primary sources, beginning with Madison's Memorial and Remonstrance, which quotes the Virginia Declaration of Rights. And these are the words that I want to end on to inspire you to read and learn more. That religion, or the duty which we owe to our Creator and the manner of discharging it, can be directed only by reason and conviction, not by force or violence. A shining example of the Enlightenment philosophy that inspired the founders and that can inspire us today to grow in wisdom. Thank you, friends. Thanks to our panelists, and look forward to reconvening on America's Town Hall